So just a quick buzzkill here. I'm not an insurance attorney. I'm a corporate attorney. I'm a partner at Barnes & Thornberg, and my practice focuses on mergers and acquisitions and private equity. And then I also serve as outside general counsel to closely held businesses and family offices. But I have had some experience with insurance, and it's been pretty unfortunate experience, which is the reason for the title, What You Don't Know About Insurance. As an M&A attorney, I've come into a couple of catastrophes right before closing big deals. Last year, 2 days before closing, I got a call from a CFO who was in a total panic because somebody had hacked into her email address and had sent from her email a fake invoice. The invoice was real, but fake wire instructions to a customer who then paid it. And this was 2 days before closing. We were wondering, what does this do to working capital? Who's responsible for these funds? What do we do? Do we call a litigator? And then in a more recent deal, I was working on a transaction for a fuel supplier and got an email from my client, less panicked, and he said, hey, no big deal. We've had a freeze, a valve broke, and we've had a spill, but we're doing all the right things. We've checked the boxes. We've called the broker. He's reported it. We've remediation is underway. It's probably going to be $500,000 to $600,000, but everything's good. And then about 2 weeks after that, we received a notice of denial from the carrier. And then he was in a full-blown panic. And so it has led to all these questions of, when something like this happens before a deal closes, or with any of your clients generally, what do you do? Who do you call, and is there something else besides litigation or a corporate solution that you can seek to help your client?
Well, I'll tell you what, you put up the bat signal and you look for someone who knows something about insurance. So thank you. So what do we do about things like that? Well, for one thing, we try to avoid having things like that happen at all. I mean, we're insurance attorneys, so we are there for your contingencies. We're also there to help you avoid them. And so with that in mind, we're going to talk a lot about insurance today. And we hope we don't impinge too much on your wonderful Chamberlain's lunch. This is not a typo here when it says what you don't know about insurance. It's not quite like Donald Rumsfeld's unknown unknowns, but there are plenty of attorneys, let's face it. Corporate counsel, oftentimes are asked to be, master of everything, right? Jack of all trades, knowledgeable about all kinds of things, employment law, corporate law, you name it. Well, sometimes they're just things that you haven't really thought you didn't know about. So that's what we're here today. So we're not trying to freak you out a little bit, but nonetheless, we're gonna kind of go through some ideas and issues here. And by the way, if at any point you have any questions, raise your hand or just shout it out. We don't mind. Even way back over there too. If you got food in your mouth, that's okay. This is lunch. So we're going to start today with an anatomy of an insurance policy, and I just happen to have a specimen sitting around in my car because that's the kind of life I lead. So we have policy forms, which you'll notice if you've ever looked at a policy, you'll see that there's a little number down here. Imagine, this is kind of a simplified idea, but if you have an underwriter is putting a policy together, the broker, other people say, okay, here's what we want to do with the policy. Well, we need to have this kind of exclusion, this type of coverage, this declarations page. So they're going to look up and say, okay, I needed policy form 1402-10190, and they just put it all together, and voila, eventually you have yourself an insurance policy. And so ISO forms is probably the most common type. If you have what is known as a commercial general liability policy, this is a very common type most businesses have. Insures you for liability for bodily injury or property damage. It's usually written in an ISO form. That's the Insurance Services Organization. That's another way of saying this is a mass-produced common type policy language. So there are, if there's disputes about what it covers, you can actually look at a lot of court decisions and say, well, on the J6 work exclusion, a court has interpreted, this comma to mean such and such. So there's a lot to go by.
So John, are these all standard across industries or with specific companies or carriers?
Good question, and the answer is generally no. With the one caveat that we have with commercial general liability policies, they often are. ISO forms are predictable, but if you notice here, we're talking about insurer forms. So we may not have industry standard exactly, but it may be that like Chubb will have a particular kind of D&O policy form, AIG will have another, and a manuscript form is just another way of saying, hey, well, the standard didn't quite meet our needs, so we negotiated something special to us. And then we have endorsements. All these are just modifications to form coverage. And what I love about some of these policies here is you may have like this first part here, which is the policy, and then this is endorsement 1, 2, 3, 4, 5, 6, 7, 8, 9. You can go up to like, I mean, I've seen policies with like 80 endorsements on them. So you've got to go through and say, okay, this one modifies section 4, paragraph B. This one deletes it entirely. This adds a new paragraph. So you got to look for that. The declarations page, that's just the front. The rest of your policy just simply says, here's the kind of coverage it is. Here's the terms on which we provide coverage. This is sort of the who, what, where, why, and when. This part here. This says, okay, this is your named insured, your policy period, which coverages did you purchase, which did you not? Do you have a self-insured retention or deductible, which we can talk about in a little bit, things like that. So those are the basic parts of an insurance policy. Everyone's going to have them. And a lot of times people don't even understand what they have. So we'll ask a client, can you send us a copy of your policy? And it'll just be like a little proposal. They'll just have, well, your policy will cover blah, blah, blah. It's a one page. It's like, that's actually not an insurance policy. And what's even worse is just not even as a coverage attorney, but calling my own insurance company. Can I have a copy of my policy for like my car insurance? And they'll send a one page. No, you don't understand. That's not an insurance policy. I don't want to be telling the insurance company what to do, but it's not an insurance policy.
So what are some typical endorsements?
A lot of times you'll have endorsements. It depends on what the company is. What like for example, if we've seen this before, like if they're places that provide youth services, there might be like a sexual abuse exclusion, or maybe there's even sexual abuse coverage for things like that. It could be all sorts of things. It's oftentimes, like I said, it's dependent on the industry, the type of company, the type of business. A lot of times they may modify things that are in the standard CGL form, like, you know, does it change like the your work exclusion, your product exclusion? The bottom line is there's probably an endorsement for just about every possible purpose under the sun.
Okay.
Okay. So now we looked at like the parts of a policy. So what are like the conceptual parts of the policy? I'll just go straight through and pop this stuff open here because the little reveal will probably take forever. So, okay. So the first thing that every policy is going to have is an insuring agreement. It's like it's a paragraph, maybe it's even a sentence. Sometimes you'll see a property policy. It'll say, this policy covers all risks of loss, except for those excluded below. And so it's just like, well, that'd be really nice if you could just limit it to just like that one sentence. And then there's like 100 pages saying, okay, well, here's all the holes in your Swiss cheese. So, so the insuring agreement is it's the foundation around which the rest of the policy is written. So then oftentimes the insuring agreement, we have definitions. For example, in a claims made policy, it'll say, we will insure claims made against the insured first made during the policy period for a wrongful act. Like, well, what does a claim mean? Okay, well, I can look that up. What does a wrongful act mean? I can look that up. And the wrongful act will be defined by other things I've got to look up. So there's a lot of nested definitions in a policy. Exclusions, we were just talking about that. This is where it basically is, okay, well, if you just simply read the policy, read the insuring agreement, this is what's covered. But we're going, you know, with one hand we give it, with one hand they take it away. So the exclusion says, okay, it would be covered, but we're not going to do that. Conditions are a little bit different because it's not necessarily substantive. It's not about the kind of things, the risks the policy covers. It's more what you have to do to ensure you get coverage. You got to notice it on time, got to cooperate with the insurance company, things like that. And then we were just talking about this, limits and retentions, deductibles. It'd be nice if, let's say, like oftentimes workers' compensation policies, it will insure anything that, you know, you're liable for under workers' comp law. Most policies aren't like that. For a certain amount of premium, they're going to cover X amount of dollars. And because you need skin in the game, there's going to have a self-insured retention or deductible. What's the difference? More emphasis. Self-insured retention usually means the insurance company doesn't have to do anything until you've incurred a certain amount of loss, whether it's defending a claim, paying something out. A deductible says the insurance company will get involved right away. It has duties, but you've got to reimburse it. So it's more an emphasis than anything else. So I'm a visual person. This isn't actually Swiss cheese. I did it as a block here. But so sort of picture this as like the world as it would be if your insuring agreement were everything. We call it scope of coverage, and this is what your exclusion does. And then you'll have an exception to your exclusion, which will put some of it back. Now, if you have a complicated policy, imagine doing this like about 100 times, and it'll look like some Lego set gone
So we did this
awry.
with the fueling company, right? We went through this analysis that we're going to cover all property damage, and then the exclusion said we're not going to cover any tanks at all,
Yeah.
or any damages caused by tanks, except we will cover tanks and damage caused by them on your customer's property. So
Right.
give it, take it away, give it back in part.
And half the time it's like figuring, okay, all right, I know it's covered, I know it's being excluded, this is the exception to the exclusion, and this is the exception to the exception to the exclusion. So this is, wait, is this reversing it, or is this?
Giant double negative.
Yeah, exactly.
Okay.
Okay, so insurance programs here. We're going to talk, so when I talk about an insurance program, what I mean is like a particular product that insures a general category of risk. So we'll talk about like things like commercial general liability insurance, D&O coverage, whatever it is. Very rarely is one insurance company going to say, yeah, well, you have $200 million exposure. Yeah, we'll go ahead and we'll insure that for you. It never happens. Or if it does, that you have an amazing broker. So the primary insurer, this is the one that usually kind of takes it on the chin. They're usually the one, they're going to pay from $0 or right above the self-insured retention or deductible. These are the ones that collect the most premiums because they're the ones that are first on the risk. They're going to be the ones paying out. And then you're going to have excess insurers that are going to sit on the tower above that. So we're going to cover loss in excess of, say, $10 million. Then you'll have a second excess that'll be, we'll cover it in excess of $20 million after the primary and first policy exhaust. So imagine it's like, I don't know, like nested boxes that like fill up with water or something like that, however you want to imagine that. And excess policies, usually they follow form with primary care or with primary insurance, which is, you know, basically what she said, kind of idea. Although the problem is it gets a little sticky because it'll say, however, we will follow the primary policy except to the extent it's inconsistent with ours. And there's like little nuggets in there. It's like, well, is that inconsistent? Is that opposite? Does that, you know, so it can get confusing really fast. Umbrella insurance, you've seen like those commercials literally with an umbrella there. All that just simply means is it's excess in some areas and primary in others. So it's excess over, let's say, commercial general liability policy, but it's primary for some special unique type of coverage. It might just say, we'll cover you for loss or wrongful act. Like, okay, well, we don't have underlying insurance to that. So the umbrella insurance drops down, basically. It's, if you, some ways, I guess you can sort of picture like if you imagine like Tetris, if you're playing Tetris with like your insurance policies, it's kind of what drop down is like. Other insurance clauses,
What does that even mean?
right? This is where this is an old idea with insurance, which is we don't want to cover something someone else covers. And so every insurer, they're gonna cover their bottom line and say, well, if you have other applicable insurance, collectible, go to them first, and we're excess of that policy. Of course, what is the other policy going to say? We're excess of any other policy that covers it. So a lot of times you have dueling other insurance clauses. The recent trend is the courts are going to say, look, you bought insurance. We're not going to let both of them, use an excuse to get out. So we're going to, as an equitable matter, we're going to treat it pro rata. They're going to have to contribute to that. Those are the easy cases. The hard one is when you have like dueling kinds of clauses. You have some policies have an SIR and some that don't. So this can get really tricky really fast. Okay, so we talked about what a policy looks like. We talked a little bit about what's actually conceptually inside a policy. how do you get a policy to even do anything? How is it triggered in the first place? So we have an occurrence policy and we have a claims made policy. Or I guess maybe we'll ask this question. Anyone in here has ever been a broker before? Probably no. Good, because I don't want to embarrass anybody. Because I once spoke in front of people years ago, and I was in front of a bunch of brokers, and I asked them, it was about maybe the same size crowd, and I asked, well, how many of you know the difference between an occurrence and a claims made policy? And they're just like a couple of, should I raise my hand? And, well, okay, I will. And it was like maybe about 5 people out of a crowd of 80. And that's scary, because when you think about what an occurrence policy does and a claims made policy does, it sounds like kind of in the weeds what the difference is. An occurrence policy basically means the policy is triggered if an occurrence happens during the policy period. An occurrence basically of bodily injury or property damage. So if the injury takes place during the policy period, it's covered, even if you report it years and years later. So like a classic example of this are like asbestos cases, things like that. If you've ever done toxic torts, someone will say, well, this building, it had asbestos since the 1940s. So you'll go back, and you may even need an insurance archaeologist to go and recreate what these policies were and say, okay, we're going to find if some of these insurers are still out there, and we're going to report something under the 1942 policy. That's what an occurrence policy does. A claims made policy is triggered not by when the injury happens, by when the claim is made against you. And so, but there's a trick. It's not just claims made, but it's also usually reported to the insurance company. And because the trigger is not the occurrence, but the claim being made and reported to the carrier, if you're 1 day late, because they'll usually say the claim has to be made and reported during the policy period. And I tell this story all the time. Imagine somebody who, let's say they're a risk manager at their company, and someone comes up and says, look, I'm here from the legal department and just want to let you know we just got sued. Tell the broker, get these people put on notice. Well, it's 4:30 Friday afternoon, I've got, kid has volleyball practice, got to go out, we're going to have Mexican food tonight, I'll deal with it on Monday. Policy period ends on Sunday. Reported on Monday, and the carrier says, I'm sorry, there's no coverage for this, and we don't have to demonstrate we've been prejudiced at all. So if that's like a $3 million claim, down the toilet. And so if your broker doesn't know that, they should. But you should know it too. Again, what you don't know, that you don't know about insurance, right?
So I guess now that we're terrified of being
if
underinsured,
I've
right,
sufficiently,
and confused.
if I've sufficiently freaked Amy out or anyone else out, let me know. We'll get the smelling salts over there.
But what are some common types of coverage, and how do we know what our businesses need? Who are we supposed to consult to ensure that we're properly insured?
Well, let me make an important distinction, because that is an excellent question, Amy. We are coverage attorneys. Now, sometimes even people in our own firm, they say, oh, so you defend cases for insurance companies. No. That's not what we do. We represent clients who have disputes with their insurance companies. So we're kind of against them. That being said, we are not brokers. So it's our job basically to be problem solvers and maybe to find problems in the way a policy is structured. We're not the ones that should tell you, okay, here's the kind of risks you have, here's the type of coverage you should have, here are the limits you should have. That is something that your broker can do. We can certainly help in that process. And we can, if they give a proposal, we can say, okay, does this policy accomplish what everyone thinks it's supposed to do? That's something we do. So we're kind of the problem solvers here, but we can't conceptualize what the policies are. So
for
right.
My fuel supplier, for example, who thought that all of his tanks were covered regardless of whether they were located, he would need to send you the policy first, or a specimen of the policy, to determine whether he actually had the coverage he thought he had?
He probably should have talked to us.
Probably should have.
Probably should have, because apparently his broker didn't do that. So we often hear about first-party insurance and third-party insurance. First-party insurance, we're not talking about, work parties or survey parties. We're not talking about Spuds McKenzie parties. We're talking about party of the first part and party of the second part type. First party insurance is basically, this is insuring you for your own loss. So we have a number of examples over here. Property policy is a great example. Workers' compensation, most people like when they have collision insurance. That's all first party. This is the insurance company saying, okay, if you lose this and it's covered, we'll pay you. So we have a number of different types of coverages here. We can go into it, but a lot of
Cyber
them,
data seems like that would have been triggered by one of the other deals I mentioned.
yes, yes, it would. And now we have third-party insurance. I'm assuming the second party is the insurance company. So this is where you're insured not for your own loss, but for your liability for somebody else's loss. So this is more kind of reactive insurance to what other parties do. We talked a little bit about commercial general liability policies. You probably heard of E&O or professional liability, D&O, management liability. Some of these are probably going to be familiar. Employment practices liability, sometimes called EPLI. We have cyber liability, multimedia liability. Sometimes there's a fuzzy line between what's first party and third party insurance. Like, for example, I think you mentioned like a data breach. If you lose information, okay, that could be a first party loss. If somebody sues you for losing that, that would be third party.
Got it.
Okay. Any questions so far? And if you're eating, that's fine. Yes?
I already told y'all's colleague I'm going to ask a lot of questions. So in the instance of the parties,
Uh-huh.
if you have an additional insured on your policy, are they the third party or the first party?
Well, if you have an additional insured, they would be considered an insured for certain purposes, but it's a third-party policy. So and we'll talk about that a little bit, but I'll just jump into that right now, though. But so a lot of times when we normally think about insurance policy, you have an insured, okay? If someone sues you, they allege you've done something wrong, you're covered. An additional insured, this is a way, and it's oftentimes like in the construction industry, where you have a contractor who's basically backstopping the upstream, the contractors, the general contractor, the owner. And so in that case, they're an insured, but only, and of course, again, there's always nuances, tons of different ways policies are written, but basically, they're an insured to the extent it relates to what you've done as an insured. That's what the additional insured would be. So they're not an insured for anything that they do, but they're insured if their liability arises out of something that the named insured has done. Limited purpose insured, I guess is what you could call it. But all that is under a third party policy because it's all liability coverage. Liability coverage is third party coverage. So good question. Okay, so, all right, so not everybody here is going to do this. I mean, we have corporate counsel here. Not everyone is necessarily a litigator, although, I don't know, I imagine maybe there are some people who are. But nonetheless, this is still a good idea because whether or not you're doing the litigating or you hire an outside firm to do it, what is the objective when you're bringing a civil suit? You want money, right?
Money.
You're really kind of you're kind of going after their money bags there. So really, I mean, obviously we heard like the settlement with Fox News and Dominion. I mean, not everybody gets like a Fox News kind of defendant to pay their bills. There could be a lot of judgment-proof defendants. So when we have something like that, we want to make sure that we have a guaranteed source of money here, insurance. And I don't know who it was, I think we were talking earlier about law school. One of the things that people do not learn in law school is insurance. It's unfortunate that should be like a basic idea. It's not just simply another bit of contract law like people would think it is. And so a lot of times when plaintiffs' attorneys, when they sue defendants, they're just alleging everything. Oh, I want to maximize that return. I want to make them look as unfavorable as possible in front of the judge. Well, you do that, you could wind out litigating yourself out of insurance. So for example, if you're alleging intentional conduct, this was just pure fraud, all along, intentional conduct. These people are a bunch of nasty knuckleheads. The defendant, they're going to get a denial letter, or at least a reservation of rights that says, we reserve the right to not defend you or limit what we're going to pay in a settlement. Also, if you're seeking things like restitution, disgorgement, there was a Judge Posner in the Seventh Circuit who once said, let's call it what it is. Restitution and disgorgement is a nice way of saying theft. Insurance policies do not cover you for things that you lose that didn't belong to you in the first place. Punitive damages, a lot of states will say, as a matter of public policy, you cannot contract to cover that. And if your policy says it covers punitive damages, it does not. You've got to be careful about what your particular state, and every state's different. Some states, punitive damages, hey, you can contract, that's freedom of contract. Other states like California and New York, there's no way you can ever contract for that. So you have to be aware of what your state allows.
So, but how did, oh, sorry. Somebody had a question?
Yes.
Does the policy language usually have a governing law that applies to state that's favorable to the insurance company, or does it really generally have a governing law be that's favorable to the insurer has to comply?
Excellent question. And the answer is probably 95% of policies do not have a choice of law clause. Some of them do. Oftentimes they pick New York because insurance companies like New York. Why? Because it's terrible for policyholders. There's a lot of bad law there. And so when you have your average insurance policy, you have to analyze, well, what law is going to apply? And usually what happens is, if you know anything about conflict of law, it's going to be the conflict laws in the state where you have the litigation. So if you bring a lawsuit in Colorado versus one in Illinois, they're going to have, one of them may say, well, the law where the policy was delivered will govern. And the other will say, well, the law where it has the strongest relationship. So, and then there are some states that will say, well, this particular claim will apply this law, this particular claim will apply that law. It can get really nasty very quickly. So, excellent question, by the way, and that's something we always have to be on the lookout for. You had a question.
Yeah, I was just curious, like, how this actually works in the real world. Like, what, how do you find out what coverage your defendant has? Like, how do you know the limits of that? As a non-litigator, how do you get to the bottom of that?
That is a great question, and that's become a bigger issue in litigation in recent years. I think, like the federal rules of civil procedure, they now basically provide that litigants, the defendants, need to provide copies of any potentially applicable insurance, and even if they don't, you should certainly be asking for that in discovery.
Okay.
So that's going to be something, because it's impossible really to litigate without doing it. But the fact is, even if you don't get the policy, you should have a sense of what is going to likely trigger a coverage denial and what isn't. And so even if you don't know the specifics here, even talk to a coverage counsel and say, okay, I'm suing them for this. What kind of coverage is going to be involved? Are there exclusions we should be looking for? You know, talk to someone who knows about that.
Are there reasons to dial this back to a negligence-based claim instead of
Could be.
asserting? Okay.
However, we have something called a final adjudication condition in a policy. A lot of times, especially D&O policies, when you have because a lot of D&O policies, they'll cover things like securities claims. It is just standard for plaintiffs to allege fraud. And this is just a given in the industry. So we have something called a final adjudication condition. It'll basically say, there's an exclusion that'll say that fraud and ill-gotten gains are not covered by the policy. However, this exclusion isn't triggered until there's a final adjudication establishing that conduct. So you can have a situation where you can litigate something, these fraud claims, and then you can settle it. And fortunately, that doesn't trigger the exclusion. Again, there's some nuances to that. That's not always the case. But what you oftentimes do not want to do is take this to a verdict, because then if the conduct is established, not only do you not get coverage for the settlement, but all the defense costs, everything that was covered before, gets zapped. So now, one thing, maybe this is a word that a lot of you are familiar with here, Stowers. Anyone knows what the Stowers rule is? Got a few.
Yep.
This is basically a rule. It has the name Stowers because there's a case named Stowers from the 1920s in Texas, but every state has this. This is basically what's known as the excess judgment rule, and that simply is when an insurer is defending a case, if there's a substantial likelihood that there's going to be liability well in excess of policy limits, and how much in excess is not always clear, how substantial likelihood is not always clear. But basically, if you've got a really huge liability exposure here, and you have a policy that only goes so far, if the plaintiff makes a demand within policy limits, the insurance company basically has a good faith obligation to treat that seriously and accept it if at all possible. The flip side is, if you have like a $2 million policy, or the defendant has a $2 million policy and you're demanding $10 million, it's above their limits. They don't have to do anything. So it's possible to be so greedy that you don't actually trigger the coverage that you're trying to trigger. The fact is, sometimes you just have to accept this is the insurance coverage defendant has, take it or leave it. And that's oftentimes, and so Stowers kind of forces the hand on that. We're doing all right.
1241.
Okay,
Yep.
yes.
So in your example where you said a $10 million, demand, but it's only like $2 million of insurance, would the plaintiff still try to sue for the $10 million, try to get $2 million from the actual insurance company and $8 million from the actual defendant?
Okay.
Hold that thought.
No, it's a good question, but so in other words, to
Can you
try,
trigger the policy as well as still going for the higher damages amount?
probably not. Because that's the thing, because you got to be willing to settle it. In fact, usually Stowers is going to require kind of like a final settlement, a global settlement to do it. So it would kind of defeat the purpose to say, okay, well, we're going to settle for this and then get the insurance company out of it and then go against basically a non-insured defendant. So that's kind of like the give and take. It's like if you're willing to take the policy limits and walk away, then we're done. But if you're greedy and you want to go for the whole 10 million or 20 million, I've dealt with a case where the underlying litigation was they were like fighting over whether it was 4.75 or 4.8 million settlement, right as the jury was deliberating, and then the jury comes out and says, well, actually, Judge, how do we allocate the punitive damages? And so the plaintiff says, okay, we're not going to negotiate, and then the verdict was $73 million. So you could try to go for that, but then again, who are you suing? Are they going to have that kind of money? Sometimes the only practical choice is to say, look, this is a small company. They don't have a ton of money here. Let's say they've got a $4 million policy. I think I can get 7. Just take the 4 and run. That's kind of what Stowers encourage people to do. It's a way to encourage settlements, really is what it is.
Now for the most important slide.
Our favorite topic, notice. One of the things that, let's see, okay, I gotta go back here. One of the things that people often ask is, if like someone has made like a demand to me, should we give notice? I'm gonna give you a sneak preview. The answer is yes. It's always yes.
But what is a demand?
Very good. Because actually that is a good issue, because a lot of times, like in a claims-made policy, a claim triggers coverage. What is a claim? It's usually defined as like a written demand for monetary or non-monetary damages. Now, sometimes it could be just a person saying, I don't like your business. You guys overcharge. Your customer salesperson was rude to me. Okay, that may be like a list of grievances for Festivus. But that's not really a demand. A demand is basically saying, you have wronged me, and if you don't satisfy my demand, there will be legal consequences. And so you can't really write down exactly what that is, but it's like the whole thing, I know it if I see it. That's kind of what a demand is. So if
It's like Our Lady at the bank.
Yes, yes. So I'll give you an example of that. So, and this goes back to the nature of claims-made policies. Remember I said, like, if you wait to even just like 1 day past like the end of the policy period, there's no coverage. That's it. Okay. So I'm going to give you a little bit of a hypothetical here, because this is going to talk about how like different claims-made policies work together and they could really mess things up. Imagine a scenario where you're running a bank. I like to use this one. And this nice lady, she writes a letter, and it actually is demand. She says, I went to your ATM and it charged me an outrageous percentage of interest here, and this is not called for, it's not on my agreement, it's not my statement or anything like that. I want you to pay it back, or I might just sue you. And you're like, well, okay, we pay enough premiums on our insurance, we really want to tell our insurance carrier about that. Maybe she'll just go away. And guess what? She does. Are we lucky or what? Maybe.
Not yet.
Now you go a couple years later, you're a couple policy periods in the future, and now an enterprising lawyer sues you in a class action lawsuit and say, your ATMs overcharge people. And you're like, this is the same thing that lady said. So you go to the carrier and you say, okay, this is a claim first made during the policy period. Aha, I reported it. I beat the rap. Well, the carrier is going to find out, maybe, they should, if you're honest with them, that, okay, there was a claim that was made 2 years ago. And we have a very interesting thing in our policy. All claims that arise out of the same or related factual circumstances are going to be deemed the same claim made when the first was made. And so the insurance companies will say, well, this class action lawsuit is a claim first made when the lady wrote the initial demand letter. Did you notice it during that policy period?
Nope.
No. So we've lost twice. We didn't give notice under the first policy period, and under the second policy period, there's no claim first made there. No coverage. And so by not responding, by not giving notice of this letter from this one individual, I've seen this happen. It could cost $5–10 million. No coverage at all.
So then who do you give notice to? And like, what is this supposed to look like? If you get a claim from a little old lady at your bank, like, who are you supposed to notify? And how many details are you supposed to give them? And is there any risk of over-disclosing?
Okay, well, there's a lot to unpack in that.
Okay.
But it's a great question. And the first thing is, well, you really should have something within your own company to make sure that you have like some kind of line of communication that people understand. If they see something, who do they talk to? Who's the ultimate repository of this information? Who has the responsibility to contact their attorneys, to contact the brokers? Now, if it's a sufficiently large company, maybe that's going to be your risk manager. Smaller company, maybe it might be the GC. But sometimes we have, I've dealt with companies where it's their chief financial officer does it. And they don't, that's just one of many hats they wear. They're not thinking about things like that. And so as a result, I'd say probably half the cases we deal with are late notice cases. And what that means is, this is a claim that would be covered, totally covered, but we're in a dispute with the carrier because it was noticed late. So it was strictly with failure to comply with the conditions of coverage. It had nothing to do with exclusions or anything like that. So giving notice is a way to avoid probably half of these coverage disputes right there. So there will be a pop quiz later on this question, but.
I just want to double click on the point where like the claims rising out of the same issue. Commercial landlord has a hole in part of the property. Person trips on it, hurts their ankle, says, hey, I want $300, I have to go get an x-ray, nothing's happened. You don't give notice. Next person, old lady goes, trips, falls, hits her head, dies, and is now a $3 million suit. In that case, if you never gave notice in the first case, that would have raised out of the same claim because that hole in the ground. Is that if I never gave notice in the first case, would the second case not be covered? I'm trying to make sure I understand.
I'm going to throw you a little curveball. Because usually when you have bodily injury cases, that's a commercial general liability policy. Those are occurrence policies. Under occurrence policy, the notice is as soon as practicable. And then there's a question, well, how soon as practicable should it be? In many states, they have what's called the notice prejudice rule, which says, okay, well, even if it's not as soon as practicable, was the insurer prejudiced? Did it lose the ability to investigate? Although there are some states, like, again, New York, our insurance company's favorite state, where there's no prejudice. Well, it's basically saying the insurance company's been prejudiced and
No coverage.
no coverage. And sometimes even if like notice of like, let's say a fire or something is like, you notice it 20 days after it happened instead of 10. There are New York cases that say the insurance, it was too late, the insurance company was prejudiced by it as a matter of law. So it depends on the state. Fortunately, Texas is actually not that bad in that regard. You had a question.
I had a question on your bank example.
Yeah.
That's a claims made policy, but not an occurrence policy.
That's right. That's right. Basically, think of it this way. For the most part, commercial general liability policies are the principal example of an occurrence policy. That's bodily injury, property damage, and then you have something called personal and advertising injury, which are things like false imprisonment, defamation, things like that. But just about any other kind of coverage is almost always going to be claims made. That's a curveball.
Including cyber?
Cyber is also usually claims made as well. Yes?
You give notice to the insurance company. Do they notice for the next year's premiums? Like, do they say, oh my gosh, you've given us, 10 of these, so we're going to increase our coverage next year?
It can happen.
Okay.
It can happen. But think of it this way. This is the way I look at it. I mean, it may not happen because you just may be a good customer, a good client. It depends on how the market is operating, the relationship you've had with the insurance company. But think of it this way. Let's say they're going to raise your rate by maybe $10,000, but you're risking the possibility you could have a $3 million claim that's not covered. So, the answer is always, when in doubt, give notice. And there's another thing here too, which I don't know whether or not we talk about, but this is actually very important for on the corporate end, on the corporate side, and I know we're getting a little bit close here. A lot of times there are internal investigations. Someone's found out about something, it could be some kind of, internal process or something like that. Or maybe it was like a stock deal and you're looking at, this is not right here, there might be some insider trading. And so you're going to investigate it. But, well, it's a claims-made policy, so there's no claim yet, right? I'm just investigating it. Well, a lot of claims-made policies have a prior knowledge exclusion. It'll say, if you knew about circumstances that could rise to a claim prior to the policy period, then that claim's not covered. And so as a result, the best way to cover yourself is what we call give a notice of circumstances under the current policy period. And then what happens is it'll say, okay, if you give us notice of circumstances during the policy period, any subsequent claim that arises out of it will be deemed to have been made and reported at this point. So you're planting the flag in that policy and saying, I'm protecting myself. One of my things I always like to say to people is if it's worth investigating, it's worth noticing to your insurance company.
Then also, who does that notice go to? I mean, we've talked about previously, the claims handler versus an underwriter. So,
Yes. A lot of times companies will think, well, shoot, I didn't really notice the claim. I'll just put it in our application for our renewal policy, and then the underwriting department will get it. And then later say, well, the underwriters got it. I know the claim people didn't, but the company got it, right? Well, courts make a distinction. They'll say that if you notice something on your renewal application, it generally doesn't, unless you can demonstrate it went to the same department, which you usually can't, the court's going to say, no, that doesn't suffice for notice. Notice says you've got to provide it to this address, and depending on what the court is, there might be, and what the policy says, maybe it'll be favorable to you, maybe not. But my attitude is, don't take a chance. If there's a claim, report it to the address and in the manner the company says. Either you do it, or make sure your broker does it, or at least confirm with your broker they've done it.
And then also where there are those overlapping policies, you want to give notice to each one of the policies, right?
That's right.
And then also if you have the stacked insurance, to make sure that every single carrier in the stack.
Overdue notice. It's okay. Yeah. There's no such
the
thing as
key
overdoing
takeaway today,
it.
right?
No such thing as overdoing it. Yes.
I have a question about the content of the notice.
What should it look like?
About the risk of
Over-disclosing.
I would not think that any of those communications with your broker or your insurer would be privileged. So if you are kind of self-reporting and then there is a claim, I guess how do you strike that balance of reporting all the relevant facts but not?
Usually if you report what you think could go into a complaint, that's fine. You don't have to say, well, we think this is a crummy claim or we're really concerned. All I have to say is, person fell down an elevator shaft on Thursday, May 4th, and and we think that this could, be $1 million claim. I mean, that's enough as long as you identify the parties, the who, what, where, when, why, right?
Stick to the facts. Don't speculate about.
No.
Sort of like an audit response letter, right? That same little short, skinny paragraph that you write that just states facts without any assessment of.
That's right. Well, like the acknowledgement letter. Yeah. That's all you want. You just want to your goal is just to make sure that you have created paper trail so your insurance company can't later say, well, we didn't know about it. We talked about additional insured coverage, so I'm going to skip that one there.
May I comment on your question?
Yes.
Just for your benefit, we rely on our broker a lot too, on that over-disclosure issue, because sometimes the carriers will be really needy and they'll we want more information, and so we rely on our brokers to act as a buffer and to make sure we're not disclosing
Go back one slide.
Oh, yeah. Thank you.
And that comes up on our next slide.
Oh.
The privilege.
Yeah, that's what I want to talk about here because this is really important. The insurance. Here's the thing. a lot of people are surprised when they find this out. Is there a general privilege in your communications with your insurance company? Is there an insured privilege? No, there is not. So when you communicate with your insurance company, you have to find some other type of protection. Oftentimes attorney-client privilege, but that's oftentimes grounded in, well, the insurance company is defending your claim. So you have a common appointed counsel, he's representing both of you. What if it's excess insured?
So that's the common interest exception.
Right.
Right, okay.
That, well,
some
there are
extent.
some arguments that's how it works. That, okay, well, if you give information about the case, like sensitive information, the excess insurer, you're not waiving it because of the common interest privilege or extension, however you want to call it. But courts are not uniform. Like, what is a common interest? Does an insurance carrier have a common interest if they've issued a reservation of rights letter, a letter that says they can deny coverage? What about the work product privilege or protection? Can you give it under that? Maybe.
So
but
then
are they a possible adversary?
As part of your practice then, do you review potential disclosures or somebody else's, like what they've drafted to disclose to their carrier and ensure that they're not inadvertently waiving attorney-client privilege?
Well, I don't think that they're, I mean, just making the disclosure isn't necessarily a waiver. I mean, there has to be privileged information. And for the most part, brokers are pretty smart that they're not gonna put a bunch of sensitive stuff in there. They want to do just enough to trigger coverage and, you know, not create a paper trail of things like that. The real trick is a lot of policies have cooperation provisions. You need to cooperate with us, provide us copies of the lawsuit papers, defense reports, things like that. Well, so we actually have had cases where you have to strike that balance. Which one prevails? My need to protect attorney-client privilege, or the insurance company's right to insist on your cooperation. And these are not resolved issues. This is a Wild West issue out there. So what we usually tell defense counsel is, try to have oral conversations. Call them up. Let's have like telephonic conferences or Zoom calls, and then they can answer it verbally, things like that. But then the other trick is, defense counsel is very good at saying, hey, you know, we got this thing covered. This is great. This plaintiff, he's just a knucklehead. You know, he doesn't know what he's talking about. We've got a great defense here. This claim is worthless. If you tell that the insurance carrier's like, well, why am I going to pay $2 million to settle this claim when I can pay, you know, $50,000, take it to trial, and then get like no judgment? So you don't want to do that. So a defense attorney has to learn to say, I know I talk up a big story to the judge and the jury and everything, but our case really kind of sucks. And we're in deep trouble here, and we really need to settle this. And it's hard to get a defense attorney to say that. That's just against every bone in their body. So, but we have to tell them insurance
Or maybe
is a
that we have
different
some really
world.
good claims, or we have, our position is strong. However, there is some risk here and here, right?
It's a very strong claim, but you see there's this landmine right
Yes,
here. Let's
that.
hope that nobody steps on that. Okay. Settling claims, just a couple other little tidbits here before we're finished.
Yep.
This is another part. It's great if you've given notice to the carrier, you cooperated with the carrier, but a lot of times what happens is sometimes people just get excited and they settle a case and they go back to the insurance company and say, oh yeah, by the way, we settled this for $12.5 million. Can you give us the money for that? Well, the carrier is going to say, well, if I go here to the settlement provision, it says that you may not settle a case or voluntarily incur any kind of liability or whatever without first getting our prior written consent. Did you get it from us? No. Is that okay? No. So, and then other policies will say you need prior written consent to even offer to settle. And of course, the other thing is carriers know that when you're trying to settle a case, you're in a bind, right? You're a little desperate. You want to get this thing behind you. And so an insurance carrier, like an excess carrier, they could say, well, you know, you have a mediation in 48 hours and you're just telling us about, we're not really in a position to evaluate this. We'll get back to you in about a week or so. You don't want to find yourself in that. So it's important that when you see an opportunity to settle come up, make sure that the primary carrier and even the excess carriers, anyone who remotely could be asked to contribute money, make sure they're in on the conversation, they know what's going on, their questions are answered, so that when the time comes up to settle, They can't say, well, you haven't kept us informed. We don't know what's going on here. It's all your fault. We need to paper that and say, no, we have done everything we're supposed to do. Okay. Now, we already talked about this, internal investigations. Remember, the rule is if it's worth investigating, it's worth giving notice. And this is just a couple last little bits here. I threw this in, but we haven't talked much about property insurance, but a couple of things to keep in mind is there are usually a couple deadlines. Like in a first-party property policy, you usually require that there's a sworn proof of loss that has to be executed within, whether it's 60, 90, whatever it is. Mind the calendar, get it done. Now, there are some cases that say, well, there's a prejudice standard, but do you really want to be arguing with your carrier over that? Probably not. One other thing that first-party policies have that third-party policies don't, especially property policies, is they will have what's known as a suit limitations period. It'll say, you need to bring a lawsuit against us no later than 2 years after the loss. So like under Texas law, for example, it's 2 years. Now, so for example, if your insurance carrier says, you must bring a lawsuit against us within 1 year, well, under Texas law, the 2 years supersedes it. If Texas law applies to your policy, if it's not, then it's different. So always know what the applicable law is. Okay. This is just a fun little bit here, but you probably already know this. Insurance companies, until you actually complete your repairs, they only pay depreciated actual cash value. So that's like an incentive there. If you're sitting on something, a project, you're not getting it repaired, then you're not getting the full value out of your policy. So, okay. Now, before anyone else asks questions to us, I'm going to ask a question to you. Yes or no? When in doubt, do you give notice?
Yay.
Thank you. That was, you have passed the test.
Okay.
Thanks, everybody.
That was great.
Oh, here, we have names.
Yeah, yeah.
Not going to do that next time with all the little stuff there. Any
Any
other
other
questions?
I have one more question.
Yes.
Practical reality is, you can be the lead lawyer in any company, but when you want to start giving notice, everyone starts talking about how these notices are going to lead to increased premiums. And there's a huge, especially at smaller companies, aversion to giving notice because they want to, they're like, we'll just self-insure. And that concept, whether you want to admit to it or not, it is
Right.
the reality.
Yeah.
Right.
And so, there's a huge tension there, but I hear you saying still give notice regardless on every single claim.
It is, yeah, you're right. It is a huge tension, and we're not going to get rid of it just by us, chanting the correct words in this room here. But it is very important, and because self-insured, you really leave yourself at risk. Some carriers will have different arrangements, we'll have a fronting arrangement, which you're technically complying with the insurance laws, but you have to reimburse your insurance carrier everything that they pay out. It's sort of like a form of self-insurance, but it's like a technically compliant form. But not having insurance at all, there are a lot of deals and engagements you can't enter into unless you demonstrate proof of insurance.
Right.
So insurance may not be an option. And so the question is, okay, well, what are we supposed to do to protect ourselves? All I can say is it's probably better to pay a little bit higher premium than besides, if it's a small issue, they're not going to care about that. Even if it's like a ton of small issues, at some point they say, okay, look, I realize they're being perfectionists, but I don't see a company threatening type of scenario. But if they do have one, though,
Rephrase my question.
Yeah.
Is there a way to argue with the broker and or the carrier that, hey, we've given you a bunch of notice claims, but you haven't had to pay out, so don't increase the
Sure.
premium? Let me ask the question different. Because if I have noticed 10 claims and they haven't, sure, they've done some work to kind of technically defend it, but have not really paid out, what is the strategy to try to avoid the premium increase? I get the fact. Look, yeah, markets have gone up. Everyone try to go buy it elsewhere. I get that. But is there a strategy that you have to try to go ahead and minimize the increase based on you noticed 50 claims or 3,000? Make your number.
Well, I'm sitting in a room chock full of attorneys, and I think one thing we would probably all know is everything's negotiable. And that is certainly true. Now, if an insurance carrier just says, look, we're going to raise your premium 500%, and we're going to have all these exclusions on there, they're probably not interested in doing business with you anyway. That might just be a poison pill telling you, go away, go find Chubb, go find AIG, stay away from us. We don't want your business. So if they don't want they'll do what they can. If they're interested in doing business with you, those little small claims you report, it isn't going to change that. It's usually going to be either because they've overextended themselves in the market, they're trying to walk away from this product.
Or maybe they're seeing a trend. Like if all of your reports relate to a series of facts that haven't changed and you're not making any improvements, I could see an exclusion from coverage for that. Or
exactly. Actually, it's a good point because we've seen, like, for example, there was a professional liability policy that was issued to a medical establishment, one of our clients, and one of their doctors was sued by a bunch of different patients, saying this guy, he was, sexually assaulting patients. The company didn't have any problem issuing the policy. It just had a big, gigantic exclusion that says, we will not cover any claims related to any services provided any way in connection with this doctor. So, voila, you got your policy. It just won't cover your main problem now. But hopefully you have the coverage of that in prior policies. So, like I said, everything's kind of negotiable, unless they don't want to negotiate. Anything else? Has your food sufficiently digested yet? If you're in a food coma, that's okay. You don't have to clap. So.
And again, how great was our CLE program?
oh, thanks. Yeah.
Thank you,
Yes,
partner.
Thank you.